Here.
Good afternoon, everyone. The judge will be on shortly.
All right, good afternoon, everyone. Thank you for your patience. This is the state expedited accusations calendar. This calendar is for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney. All participants, this proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch this particular proceeding. Have all members of the Public Defender's Office had the opportunity to interview their clients?
I have, Judge. Good morning,
All right.
good afternoon.
Good to see you, Mr. Howard. Thank you. Those who receive a signature bond today will be reset for the notice. Those who receive a surety or cash bond will be reset to the state all-purpose calendar on March the 9th. Who do we have first?
Good morning, Your Honor. Good afternoon, Your Honor. This
Good
is
afternoon.
ACDC. Before you is Ms. Belzazer, position number 1.
All right, Ms. Belzazer. I'm Judge Melanie Williams. Your case is 23 CR 001075E. In this case, you're charged with theft by shoplifting, simple assault, and disorderly conduct, each with the offense date of February the 24th. Do you understand your rights?
Yes.
All right. Who do I have from pretrial? Ms. Bostic. Ms. Bostic, can I please have the history for position number 1, please?
No prior arrest history, Judge.
All right, thank you so much. All right, and whose case is this for the state?
That's me, Dina Gardner, Your Honor.
Good afternoon, Ms. Gardner. May I please have your recommendation?
Good afternoon. Yes, in this case, the defendant left the store with a bag of chips, candy, and a beverage past the point of sale and out the door. Security officer Gary Scott tried to stop her, and she threw the beverage at his face and then started to swing and kick violently towards him. He took her to the ground, and then she tried to hit him with a metal trash can lid. The officer noted that surveillance video did confirm these facts, and the items she stole were recovered. The state is recommending a good bond in the amount of $1,000 for the first count of theft by shoplifting, to stay away from the Quick Trip at 1678 Howell Mill Road, and to have no drugs, alcohol, or weapons while on bond. On the second count of simple assault, the state is recommending a $2,000 good bond and no contact with Gary Scott. And the same on the third count of disorderly conduct, a $2,000 good bond and no contact.
The charges that I have are theft by shoplifting, 1 count of simple assault, and disorderly. Are you saying there's 4 charges, Ms. Gardner?
No, Your Honor. That was 1,000 good bond on the first count of theft by shoplifting, 2,000 good bond on the second count of simple assault, and 2,000 good bond on the third count of disorderly conduct.
Okay, understood. Thank you. Mr. Howard, do you represent this defendant?
I do, Judge.
All right, please proceed.
Yes, Judge. Ms. Belzaire is 27 years old. She has lived here off and on for the past 5 years. She's been here most recently looking for job opportunities. She's not currently employed, so we're going to ask the court to consider a signature bond given her financial state. Given her lack of criminal history, Judge, and there's nothing in her history to indicate she wouldn't return to court. She didn't have any failure to appears or probation violations. And this is, her first offense. So we would ask the court to consider a signature bond of any amount and a $500 bond on each charge if it were to be a surety.
All right, at this time, defendant will receive $1,000 signature bond through the jail, $250 for the theft by shoplifting, $500 for the simple assault, and $200 for the disorderly conduct. $250 for the disorderly conduct. That should be the total of a $1,000 signature bond through the jail. She is to stay away from the address on Howell Mill Road. I believe it was 1678, and she's to have no contact whatsoever with Mr. Scott. Additionally, she's to have no drugs, alcohol, or weapons as a condition. Is there anything further?
Nothing further, Judge.
Nothing further, Your Honor.
All right, best of luck to you, Ms. Belzaire.
Your Honor,
Yes.
my camera had froze. Can I get from the theft by shoplifting and?
Yes, it's a $250 SOB through the jail, followed by a $500 SOB through the jail, then a $250 SOB through the jail, for a total of $1,000 SOB through the jail.
All right, thank you.
All right. Best of luck to you, ma'am. What do we have next?
Position number 8, Ms. Watkins.
All right. Good afternoon, Ms. Watkins. I'm gonna have to look at this. Hold on one second. Let me see. Ms. Watkins, while I'm pulling up your case, do you understand your rights today? All right, give me 1 second. All right, and your case number is 23 CR 001082E. You're charged with criminal trespass and disorderly conduct with the offense date of February the 22nd of 2021. May I have her history, please, Ms. Bosick?
Judge, in regards to Ms. Watkins, no prior arrest history.
All right, thank you. Mr. Hollings, is this your case?
Yes, Judge, it is.
All right, please proceed with your recommendation.
Yes, Judge. Defendant was seen on a ring doorbell around 4:13 in the morning at a house owned by the victim, Miss Isha Dorsey, and that's ISHA DORSEY. When she was walking up to the defendant's, what we believe to be a vehicle that's owned by the defendant and her, I believe, husband. She slashed the tires on the SUV, and the location of the incident location, excuse me, is 6463 Short Road in South Fulton, Atlanta, Georgia. Once she slashed those tires, she then walked up to the porch of the house. She struck and kicked the door multiple times, and then turned to a window, used a knife to break the window that she had to slash the tires. Inside that window, there was a 2-month-old infant sleeping directly underneath it, as was testified, or I guess was told to the officer by Ms. Dorsey. The state is recommending a $5,000 surety bond on the first count and a $5,000 surety bond on the second count. The reason why, Your Honor, is because the defendant damaged property with an indifference to who was on the other side of that property or the window. Additionally, she did use a knife during the commission of a crime, and has been eluding officers essentially since the warrant was placed out for her arrest. And thus, we do believe she may be a potential for a flight risk. And you were also asking for no alcohol, drugs, or weapons while out on bond, and a stay away from the incident location, and no further contact with the victim, Ms. Isha Dorsey.
All right. I'm going to sound for Ms. Dorsey. If Ms. Dorsey is present on the Zoom conference and wishes to make a statement, this is your opportunity to do so. Ms. Dorsey, is this you?
Yes, I am. This Aisha Dorsey.
Would you like to make a statement? You're not required to. If you want to, I'll need you to raise your right hand so I can place you under oath.
Okay.
All right. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right. What the court is most interested in is whether you wish to have contact with the defendant. What would you like to tell me at this time?
No, I would not like to have contact with her. I just want to say, what she did here at my home, it caused me a great deal of mental stress. I mean, for me and my family both. I don't know her. That was my first time seeing her on the camera. And as you, when you seen her on the camera screaming through the window, and I don't know what is to become of this, but I just pray that she just don't just get to do this and get away with it, because
Yes,
since it's hard for me here, being woken up out of your sleep, as you can see how she just start kicking on the doors and stuff. So I have problems with that now.
All right. Thank you for making that statement. I appreciate you coming to court, Ms. Dorsey.
Mhm.
Mr. Howard, would you please proceed?
Yes, Judge. Ms. Watkins is 37 years old. She has lived in Georgia for most of her life, for more than 27 years. 15 of those years, she honorably served her country in the United States Air Force. She was honorably discharged in June of 2020. She is gainfully employed as a security officer with QT Protective Services. She's been on that job for several months now. And I guess the state's position that somehow she is eluded capture or something along those lines is just not the case, Judge. She works here, she lives here, she's not hiding, she can be found. She has 4 minor children that she shares with her husband. So she is certainly someone who intends to return to court to answer these charges. Judge, just a little context, there's a lot going on in this case. Miss Dorsey did mention that Miss Watkins' husband was having an affair with her, and they subsequently had a child together. So just to give a little context about the relationship, she has no desire to have any contact whatsoever with Miss Dorsey, so the no contact is just fine with her. Given that she does not have a criminal history, there's nothing to indicate she would not return to court. She absolutely intends to return to court to answer these charges. She will not qualify for the services of the public defender after today, based on her income, Judge. So we would ask the court to allow her to sign her own bond in this case. This is an allegation from almost 2 years ago. So we would ask the court to take all that into account.
All right, thank you. At this time, Ms. Watkins is going to receive a split bond. It's going to be a $1,500 signature bond through pretrial services for the criminal trespass and a $1,500 surety bond for the disorderly conduct for that total of the $3,000 total bond. She is to stay away from the location on Short Road in South Fulton, Georgia. She is furthermore to have no contact with Ms. Dorsey whatsoever, and she is to have no alcohol, drugs, or weapons as a condition of that split bond. And I do recognize that split bond will be per judge. All right, is there anything further?
Judge, you said $1,500 on the first charge?
Yes,
Okay,
$1,500 each charge. Is just one is surety and one is good.
Thank you, Judge.
All right, best of luck to you, Ms. Watkins. Who do we have next?
Good afternoon, Judge Williams. Good afternoon, Judge Williams. This is going to be position number 1, Mr. Franklin, and he also has a private attorney.
Is that the one on the add-on calendar?
Yes.
Yes, it is.
Okay,
Excuse me.
all right. All right, Mr. Franklin, your case is 23 CR 001084Y. In this case, you're charged with reckless driving, fleeing or attempting to elude, making an improper U-turn, and willful obstruction of a law enforcement officer, each with I don't have the offense date, but I'm sure the state will give me that. Do you understand your rights? I'm assuming he's saying yes. All right, Ms. Bostic, can I have his history, please?
Judge, in regards to Mr. Franklin, he has 3 felony convictions. He has 3 arrests for a probation violation, 1 FTA in 2014. He's currently on probation for aggravated assault with a deadly weapon firearm by a convicted felon, sentenced February of 2022 for 3 years. He has another open case, 22 CP 214048, fleeing and eluding, hit and run, driving without a valid license, and marijuana. Nothing further.
All right, thank you. Ms. Gardner, please proceed.
Thank you, Your Honor. The facts alleged in this case are that APD officers Ware and Diaz-Taylor saw a white Kia Stinger make an illegal U-turn at the intersection of Delmar Lane and Harwell Road. This was on the 23rd of this month, around 4:30 in the afternoon. As they followed the Kia vehicle with lights and sirens, it fled from them at a high rate of speed. The officers noted that the vehicle accelerated so quickly that they could hear the engine rev and see the rear of the vehicle hunker down, were their words. And they did note that the vehicle was traveling at 60 miles per hour. Eventually, the officers saw 2 men abandon the vehicle and flee on foot. This defendant was identified as the driver by the cream-colored sweatsuit that he was wearing. The law enforcement officers saw them jump over a chain-link fence and throw items from their persons onto the ground as they ran. The officers commanded them to stop, but they continued to run. They were eventually caught trying to jump over another fence. The officers found a Glock handgun in the area where the men were throwing the items. Franklin's companion stated that the Glock belonged to him. We suspect that this case will be transferred as a felony when we find out for certain what the speed limit in that residential area was. Our investigator did speak with one of the officers. He believes that the speed limit was 25 miles per hour. So at 60 miles per hour over, he was definitely exceeding the 25 miles per hour over the posted speed limit, and in traffic conditions that put the general public, at least in that community, at risk. In addition, the open case that he has is factually very similar to this case, and that one he's still waiting to be heard on. As noted, he has 3 felony convictions. He has 15 cycles with numerous convictions, 3 of which are probation violations and a failure to appear warrant. We believe that there's a very high risk of him committing a felony while on bond and committing more offenses and failing to appear for court as he has in the past. The state is requesting a $5,000 cash bond, no driving and no drugs, alcohol, or weapons on count 1 of reckless driving, a $3,000 good bond on count 2, fleeing or attempting to elude, a $1,000 good bond on making an improper U-turn, and $1,000 good bond on the obstruction charge. I understand he also has a probation violation hold.
All right, thank you. Mr. Mitchell, if you give me your position regarding bond.
Yes, Your Honor. Mr. Franklin, he is 36 years old. He's a native of Atlanta, and so he does have ties, strong ties to the community. He has a job with right-of-way landscaping, and so he's employed. He has a job, and he is has roots here. I would like to hear when the last FTA would have been. He's been coming to court with the last few years that he's had court appearances, so there are no issues with him coming to court. So with that being said, we would just ask that we could get $1,000 for each charge as a bond for Mr. Franklin. These are misdemeanors, and so he could be able to come to court in that regard.
All right, thank you, Mr. Mitchell. Let me do hold on 1 second. All right, defendant is going to receive a total of a $5,000 good bond, $2,000 count 1, and $1,000 on each of the remaining charges that should equal the $5,000. He's not to drive, and he moreover is to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing from the state, Your Honor.
Well, yes. Is he being held for probation?
I'm unaware. I'm not sure. Ms. Gardner, you saw a probation hold?
Yes, on the jail screen.
Yeah, so there's another hold that I believe I can't address today, but he does not have bond on these charges.
Okay. Do you know who he addressed that with? Is that with the Superior Court judge he's before?
Likely so, yes.
Okay. Thank you, Your Honor.
All right. Does that conclude your business, Mr. Mitchell?
Yes, Your Honor.
All right, you can be.
Well, how do we get an order?
The orders will be scanned in. I don't know if you need well, I actually can't answer that question. I honestly don't know how you get it, but typically I know I sign them. They get entered into the Odyssey system, and from there he'll be able to be to make bond through the jail.
Okay.
Or wherever. Okay.
Thank you.
All right. Take care. All right. Who do we have next?
Position 4, Jackson.
All right. Good afternoon, Mr. Jackson. Your case. Good afternoon. Your case is 23 CR 001079B. You're charged with 1 count of battery, family violence, with the offense date of February the 24th. Do you understand your rights?
Yes, ma'am.
All right, Ms. Bostic, may I have your history, please?
But in regards to Mr. James Jackson's extensive criminal history, 32 cycles, at least 14 felony convictions, 2 misdemeanors, well, 3, 1 being a 2015 battery, 2 arrests for a probation violation, a very old FTA, nothing further.
All right, thank you. Ms. Gardner?
Thank you, Your Honor. The facts alleged in this case are that back on February 24th of this year, early in the morning, Ms. Keyshawn Watts saw the defendant outside of the home they shared together making a transaction with someone. When he returned to their bedroom, she confronted him about this, wanting to know what he had been doing. They began to argue, and the defendant hit Miss Watts in the back of her head and then punched her face repeatedly. Officer Vo did note a laceration on Miss Watts's lip. They are in a relationship and live together. And as stated, he has extensive criminal history with multiple and many felony convictions. He has an FTA and 2 probation violations on his record. The state is asking for a good bond in the amount of $3,500, anger awareness that he stay away from the incident location at 1608 Orlando Street Southwest and have no contact with Miss Tishawn Watts. Her name is spelled Tishawn, and then Watts is Watts.
All right, thank you. I'm going to sound for Ms. Watts. Ms. Watts, if you are present on the Zoom conference and wish to make a statement. Or is she in the gallery?
My daughter, Miss Watts ain't showing them.
All right. No, Ms. Watts. All right, Mr. Howard, this is your client.
Yes, Judge.
All right, please proceed.
Mr. Jackson is 66 years old. He is a lifelong Georgia resident. He has significant ties to the community. As you heard, he has family and those there in support of him in the gallery today. And he currently receives a monthly payment for medical, a host of medical disabilities that he has. So he has a limited income. And Judge, we dispute the facts in this case. Mr. James Jackson tells me that the incident is related not to some mythical transaction, but rather his announcement to Ms. Watts that he would not continue to be with her. He indicates that she was very upset by this and that she threatened him that if he left or tried to leave, that she would make sure he paid for it and that she was going to get the police out. He tells me that that is what led to this incident. And there's an allegation of a visible injury. He said she told him that she would bite her lip and make sure the police thought that he did it. I would note there's an allegation he hit her several times in the face. However, the alleged injuries don't support a man of his size hitting a woman in the face several times and there not being any other visible injury than a laceration on the lip. Judge, he doesn't have a history that's recent as it relates to violence. I did hear a 2015 battery charge, but that's been 7+ years ago. The failure to appears, I didn't hear the date of those, but I would be interested to know if those are recent. And while he does have a felony history in the most recent history, it doesn't appear to be any type of violence or any felonies in his recent history. So we would ask the court to consider a signature bond of any amount in this case. He is absolutely fine with no contact. We've already discussed him being able to reach out to law enforcement to go and retrieve his things one time. He can stay with family members. So he is fine with the no contact. So we'd ask for a signature bond, Judge.
All right, and this
Your
time.
Honor?
Yeah.
I'm sorry, if I may, I just wanted to note that the story that this defendant has told his attorney is quite different than that he told the police officer. The police officer stated that he said that they got into an argument because she came home and he asked her where she had been and she didn't want to tell him.
Okay. At this time, defendant will receive a $2,500 good bond. He is to have no contact whatsoever with Ms. Watts, and he is to stay away from the address on Orlando Street. Moreover, he can return one time with a member of law enforcement to get any items. Additionally, he's to have no alcohol, drugs, or weapons as a condition of that surety bond, and he will be reset to state all purpose on March the 9th. Is there anything further?
Nothing further, Your Honor. Thank you.
All right, best of luck to you, Mr. Jackson. Who do we have next?
Position 2, Cameron.
All right, good afternoon. Your case is 23 CR 001076H. In this case, you're charged with battery, family violence, and cruelty to children in the 3rd degree with the offense date of February the 8th. Do you understand your rights?
Yes, ma'am.
All right, Ms. Bostic, can I please have the history?
In regards to Mr. Cameron, 13 cycles, he has a prior battery conviction in 2016. That victim was and it was Tina Hardy Middleton. 2 misdemeanors, misdemeanor possession in 2019, a 2020 disorderly conduct, an FTA, in 2019, currently on misdemeanor probation out of Fayette for misdemeanor possession. Sentenced June 13, 2022 for 12 months. Nothing further.
All right, thank you. Ms. Gardner.
Thank you, Your Honor. The facts in this case are that the defendant and Miss Roderica, that's Roderica, Brock, were living together in a relationship, and they argued about the defendant giving Miss Brock a ride to the beauty store. As they were entering the apartment in which they resided together, they were arguing. The defendant stepped on Miss Brock's heels. Miss Brock told her to stop, and the defendant punched Miss Brock in the mouth with a closed fist, yanked her hair, and pushed her in the bushes beside the residence. Miss Brock went inside to call the police. A while later, the defendant came back to the residence and resumed the argument. Miss Brock asked her to leave several times, and then the defendant struck her again. Miss Brock asked her 14-year-old daughter, who had witnessed all of this, to call the police that time. They had already come once and not seen them, so they returned. Miss Brock stated that as she left, the defendant flipped over the living room table and knocked over a lamp, breaking it. The law enforcement officer was able to see a laceration on Miss Brock's upper and lower lips. We're asking, we also see an FTA in 2022 with her rather extensive history and her violent history, as well as the FTA. We are asking for, on the first count of battery family violence, a good bond in the amount of $2,500, stay away from the residence they shared at 8064 Fulton or South Fulton Parkway, no contact with Roderica Brock or her daughter, Trinity Anthony, anger awareness, no drugs, alcohol, or weapons while on bond. And on the second count of cruelty to children, and the third, we're asking for another good bond in the amount of $1,500.
All right, thank you. I'm sounding for Ms. Brock at this time. Ms. Brock, if you're present and wish to make a statement. All right, hearing and seeing none. Mr. Howard?
Yes, Judge. Ms. Cameron is 26 years old. She too was born and raised here in the Metro Atlanta area. Her mother and her siblings still live here in the Metro Atlanta area. She's a graduate of Banneker High School, and she does work full-time for a company called SDS Transportation, where she's a shipping and receiving clerk that's located out in Palmetto. Actually, she won't qualify for our services after today once she's released from custody. And Judge, she did tell me there was an argument, but we dispute that she was the aggressor in this incident. She indicates that Ms. Brock was actually the aggressor in this incident. And we believe, once we have an opportunity to delve more deeply into the facts, that we'll be able to show that. As it relates to a history, Judge, we show that she had a conviction in 2016, which was more than 6 years ago. We did hear that there may be some recent FTAs. However, I can tell you she is motivated to return to court to continue to address this matter. She is understanding that she may not be able to go back to that address. However, she told me that Ms. Brock has reached out to her since she took out the warning. They've spoken and had contact. However, I was not able to reach Ms. Brock either to confirm. So we understand it may not be a no further violent contact today. But we would ask the court to take into account the fairly limited history and how remote the last conviction was, and consider $1,000 on the battery and $1,000 on the cruelty. We'd ask that the court consider that in terms of a signature bond, but if not, we'd ask that the surety bond be no more than those amounts.
All right, thank you. At this time, defendant will receive a total of a $2,500 surety bond, $2,000 on count one, $500 on count two. She's to have no contact with Ms. Brock, and she is to stay away from the address on South Fulton Parkway. She can return one time with a member of law enforcement to get any items. Additionally, she's to have no drugs, alcohol, or weapons. Is there anything further?
Nothing further, Judge. Thank you.
All right, best of luck to Ms. Cameron. What do we have next?
Position 3, Davis.
All right, Mr. Davis, good afternoon. Your case is 23 CR 001077A. You're charged with theft by taking with the offense date of February the 23rd. Do you understand your rights?
Yes, ma'am.
All right, Ms. Bostic?
Judge, in regards to Mr. Davis, 7 cycles, a 2013 criminal trespass, 1 FTA in 2014, probation violation in 2020, currently on felony probation, sentenced in 2018 for an aggravated assault, aggravated battery, and firearm during, sentence 6/8/18, 3 years confinement, 7 years probation. Nothing further.
Thank you. Ms. Gardner?
Thank you. The facts in this case are that Mr. Davis went into free at last bail bond on February 23rd around 4 p.m., ostensibly inquiring about some defendant paperwork. However, when he spoke to Miss Jasmine Webb, who works there, he gave her 2 false names. When she told him that he was not telling her the truth about his names, he took her lunch off the counter as well as her business keys and left the establishment. Mr. Webb followed him and asked him to return the keys. And at that time, defendant took off his pants and threw them into an adjoining parking lot. Ms. Webb was able to retrieve the keys from his pants. The report indicates that defendant then went to a Mr. Skylar Ballard to use his cell phone. When Mr. Ballard handed him the phone, the defendant took a SIM card out and then returned the phone to him. When Ms. Ballard asked for the SIM card back, the defendant refused to give it to him and walked away. Then he went to ask to use Mr. Gandhi's phone. The defendant took this phone and threw it on the ground, damaging the screen. Then he took off again. Mr. Ballard and Mr. Gandhi tracked him down and demanded the SIM card. A fight then broke out between the 3 men, which is when law enforcement Officer Harris found him. Mr. Davis admitted doing all of this to APD Officer Harris. Mr. Ballard and Mr. Gandhi expressly stated they did not wish to press charges. However, he is charged with the theft by taking from Miss Jasmine Webb. Given his history, his failure to appear, his probation violation, and the fact that he's currently on felony probation at this time, the state is asking for a $1,500 good bond, that he be required to stay away from free at last bail bond at 233 Peachtree Street Southwest, and that he have no contact with Miss Jasmine Webb, and that he have no drugs, alcohol, or weapons while on bond.
All right, thank you, Ms. Gardner. Mr. Howard?
Yes, Judge. Mr. Davis is 30 years old. He is a graduate of, he attended Crim High School in the Metro Atlanta area and was born and raised here. Judge, there was some confusion about the actual bonding company that he was supposed to be at. It turns out it was a adjoining bonding company that he was looking for. However, I heard a number of allegations that are not even alleged in the warrant, Judge, about SIM cards and other matters which are not before us. So we would ask the court not to take any of that into account. And as we know, anything said to here today are simply allegations. There are no facts. Nothing's been proven. We would ask the court to take into account his history. I did hear that he had a felony probation matter from many years ago. He's currently on probation, Judge, but I would ask the court to take into account, doesn't appear to be a history of not returning to court. He gave me an address on Hillside Village Drive that he's lived at for 9 years, and he will certainly return to court to answer these charges. We'd ask the court to consider a $500 bond in this case. We'd ask the court to consider a signature bond, given he's currently not working. He's attempting to enroll in school, and he has a job opportunity at Crystals that he just needs to return the last part of the paperwork that they need. So he hopes to be able to have employment soon, but he does have limited financial means. So we'd ask the court to consider a signature bond in this case.
All right. Defendant will receive a $1,000 good bond. He's to have no contact with Miss Jasmine Webb and stay away from the address on Peachtree Street. Additionally, he's to have no drugs, alcohol, or weapons as a condition. Is there anything further?
Nothing from the state, Your Honor.
All right, best of luck to you, Mr. Davis. Who do we have next?
Position 9, Watley.
All right, give me one moment. All right, good afternoon. Ms. Watley, in this case, let's see. I'm sorry, Mr. Watley. In this case, you're 23 CR 00108 3C, you're charged with battery of family violence with the offense date of December the 18th of 2022. Do you understand your rights?
Yes.
All right, thank you. Ms. Bostic, can I have his history, please?
Judge, one prior arrest and he's on misdemeanor probation for that charge for driving with expired license, sentence 8/23/22 for 6 months. Nothing further.
All right, thank you. Mr. Hollins? You're muted if you're speaking.
Sorry. Yes, Judge, the defendant assaulted victim Imani Sharif, and that's IMANISHARRIEFF at the incident location, which is 933 Cruz Street, and that's CREW Street Southwest in Atlanta, Georgia. This occurred after Ms. Sharif posted a picture on social media with another man, and she refused to take it down after the defendant asked her to. The defendant grabbed Ms. Sharif around the neck and pushed her against the wall. He then attempted to take her phone to delete the message, but she ended up getting her phone back and running into the bedroom. At that particular time, the defendant pushed her to the side of the bed and then struck her several times. Upon seeing the police arrive, the defendant ran away from the scene, and officers gave chase, but were unable to arrest. Your Honor, we're obviously concerned about the flight risk, as he ran away from the police and is presumably running away from being arrested. Additionally, Your Honor, he went into the victim's house and did this act, which is obviously a risk of intimidating her as a potential witness in the case. At this time, Your Honor, the state is asking for a $5,000 surety bond on the battery family violence, no alcohol, drugs, or weapons while out on bond, a stay away from the incident location, and no further contact with victim Ms. Imani Sharif.
All right, I'm sounding for Ms. Sharif at this time. If you would like to make a statement, you're not required to do so. I do see Imani on the screen. If you want to make a statement, you'll need to turn on your camera so we can identify you. All right, there we are. We still can't really see you. If you could, all right, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, what would you like to tell the court? What I'm most concerned with is whether you wish to have contact with the defendant.
I'm not fearful of him or anything. It happened a while ago. We already resolved it. I was just mad. I never wanted it to go that far. We've been doing good ever since, and we worked it out. We lived together. We worked together. He was a great father, and I'm ready for him to come home for me and my son.
All right, thank you.
Thank
I appreciate you making that statement. Mr. Howard?
Yes, Judge. Mr. Watley is 19 years old. Though he's young, Judge, he's responsible enough to have a full-time job so that he can provide for his 1-year-old son that he shares with Ms. Sharif. He works for Hawkeye Protection as a security officer. He's been on that job for about a year. As you heard, Judge, it doesn't appear he has any history except an expired license charge. There's nothing to indicate that he's likely to commit new offenses or that he wouldn't return to court to answer these charges. He attended Maynard Jackson High School here in Atlanta. He does have family that still lives in the metro Atlanta area, so he does have significant ties to the community. So we would ask the court to consider a signature bond in this case and no further violent contact so that he can maintain a relationship with his son. And given Ms. Sharif's statements, we believe that would be appropriate.
All right.
At this time, we would just ask for no further contact until we've had an opportunity to investigate a little bit more.
All right. At this time, the defendant will receive a $5,000 SOB through pretrial per judge. He is to take the 1-day anger awareness course. He's to have no further violent contact with alleged victim, last name Sharif, and he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further, Judge.
Nothing further.
All right. Best of luck to you, sir. Who do we have next?
Position 7, Thomas.
All right. Let's see. Good afternoon, Mr. Thomas. Your case is 23 CR 001081F. In this case, you're charged with 1 count of obstruction, 1 count of criminal trespass, and 1 count of fair evasion, each with the offense date of February the 24th. Do you understand your rights today?
Yes, ma'am.
All right, may I have the history, please, Ms. Bostic?
Judge, which time is 6 or 7?
7.
No prior arrest history.
All right, thank you. Mr. Hollins?
Yes, Judge. Officers observed the defendant skip paying the fare at the incident location of 70 Hamilton E. Holmes Drive Northwest, and that's the MARTA station. After approaching the defendant and asking him to leave multiple times, officers eventually placed him under arrest. While attempting to place handcuffs around the defendant, he continued to push away from the officers and refused to place his hands behind his back after being given.
I'm sorry, excuse me, I'm sorry, it's the wrong defendant that you're reading the, that's.
Okay. The wrong person approached us. This is Mr. Thomas?
Yes.
Milan
This is
Thomas.
Mr. Thomas, but the other guy that he was reading was, all right.
Well, that was Milan Thomas that I was just reading, but who was just up here must have been Mr. Jay Sean Thomas.
Yeah.
Okay, so are we doing position 6 or 7?
Okay, there's 2 Thomases, so there's Milan Thomas and also Jason Thomas.
Right.
The one that was we were on was,
Milan.
no, we were on Jason Thomas. So go back.
Well,
You were just using the wrong, what is it? That was the wrong
Well,
case.
since we've already had the history, can we just do Mr. Milan
Yeah.
Thomas?
Yeah, let's do him.
Let's stick with him since we have the facts and we're almost there. All right, thank you, and I do appreciate that. Mr. Thomas, before we continue, do you understand your rights today?
Yes, I do.
All right, thank you. All right, Mr. Hollins, please continue.
Okay, Judge, and once the officer asked him to place his hands behind his back because he was being arrested, he pushed away from the officer and refused to do so after being given several commands. Seeing as this is his only arrest, Your Honor, we're asking for a $1,000 signature bond on each count, no alcohol, drugs, or weapons while out on bond, and compliance with any MARTA suspensions that may be in place.
I'm assuming you don't object to that, Mr. Howard. That's what I was
No
inclined to do.
No
All right.
objection.
Defendant will receive a $3,000 SOB through the jail, 1,000 each count. He is to comply with any active MARTA suspensions and have no alcohol, drugs, or weapons as a condition. All right, Mr. Thomas, best of luck to you. We don't want to see you back here. All right, can we take the next Mr. Thomas now, position 6?
Was it SOB through the jail?
Yes. All right, Mr. Thomas, you've already indicated that you understand your rights, but your case is 23 CR 001080E. In this case, you're charged with willful obstruction, possession of marijuana less than an ounce, and possession and use of drug-related objects with the offense date of February the 24th. Confirming you understand your rights?
Yes, ma'am.
All right. Ms. Bostic, can I have position 6 as history, please?
No prior arrest, Judge.
Okay, thank you. Mr. Hollings?
Yes, Judge. And in regards to the history, they're potentially, I'm not sure because we haven't had an opportunity to run an NCIC, but the defendant, as I understand, is a resident of New York. And so there potentially could be some history there, may not be. But officers observed 2 males riding scooters on the sidewalk, which by Atlanta City ordinance is prohibited. As officers approached and explained that they were unable to ride on the sidewalk, the defendant stated that he was from New York and that officers should just give him a warning. Officers asked for identification from the 2 males and the defendant refused. Defendant was then informed that if he did not provide identification, that he could be arrested. Again, the defendant refused and told him that he should just told the officer, that the officer should just give him a warning. Officers at that point placed him under arrest, and as they were attempting to cuff him, he pulled away and pulled his phone out and began acting out while and also attempting to walk off. After he was arrested, a search incident to arrest yielded 18.5 grams of raw marijuana, a scale, and a grinder from the defendant's book bag. Your Honor, we normally would null process the marijuana charge. However, because this is we're a little bit concerned that because there was a scale and a grinder, that there could potentially be some type of distribution going on. We have reached out to the DA's office for felony transfer, and they have denied that. However, we are not inclined at this time to null pros the marijuana charge. The defendant is not from Georgia, and a signature bond would not be appropriate for someone who likely will not show up to court if he's given a signature bond. He lives, on the other side or the north side of the country. And additionally, he tried to leave when officers tried to place him under arrest. And for that, Your Honor, we are asking for a $1,000 surety bond on each count, no alcohol, drugs, or weapons while out on bond.
All right, thank you. Mr. Howard?
Yes, Judge. Mr. Thomas is 20 years old, and he in fact does live here, has lived here for the past 3 years. He's currently employed full-time for Arby's as a shift manager. He's been on that job for 3 months. His aunt works at that same location. He has every intent to return to court to address these charges. Since he has no history, obviously he's motivated to try to get the best possible outcome in this case. He lives at 3450 Evans Road and has lived there with his aunt and his grandmother for a significant period of time. So the state's belief that he lives somewhere other than here is not factually correct. Judge, given he has no prior history and this incident arose from an allegation of riding a scooter on the sidewalk, and I guess if the officers are gonna stop and arrest people or accost people for that, they probably wouldn't have time to do anything else, because every time I see people on scooters around the city, it appears they're on sidewalks. So in this case, they decided to stop him. He was unaware that it was an ordinance. He indicates this was actually the first time that he had ridden a scooter, since he'd been here for the past 3 years, and he was not aware. And when he began to ask the officer why he was being stopped, he indicates that the officer became very aggressive, didn't give him an opportunity to produce a license or anything else. He ultimately was taken to the ground by the officer and another officer that showed up on the scene. So we believe it's just a bit overzealous by the officers from our perspective, Judge. And given his lack of history, we'd ask the court to consider a signature bond on these charges.
All right, thank you. At this time, defendant's going to receive a $1,500 split bond. It's going to be $500 surety on count 1 and $500 signature on each remaining count through the jail for the total of $1,500 split. Were there any special conditions requested by the state? I don't recall.
I just asked for no alcohol, drugs, and weapons while out on bond. The incident location it says 585 Memorial Drive Southeast, but I mean, he was on the scooter.
Right, but he was on the sidewalk, so
Right.
it's not really a particular
Correct.
place. All right, so a stay away is not appropriate in this case, but moreover, he is to have no alcohol, drugs, or weapons as a condition. All right, that concludes Mr. Thomas's case. Best of luck to you, sir. Who do we have next?
Position 5, O'Neill.
All right, Mr. O'Neill, your case is 23 CR 001078F. You're charged with criminal trespass and theft by taking, each with the offense date of September the 17th of 2021. Do you understand your rights?
Yes.
All right, Ms. Bostic, may I have that history, please?
Judge, in regards to Mr. O'Neill, 3 arrests, 2 open cases, and 1 FTA open case in DeKalb. For 1 case is a criminal trespass and theft by shoplifting. Other open cases of reckless conduct. 3rd arrest is for an FTA from 2023. Nothing further.
And Judge, I would ask if we could have a quick breakout with the state to
Sure.
discuss this matter.
Miss Grace, will you please place me, or Miss Champion, will you place me, Mr. Howard, Miss Gardner? I'm assuming Miss Allen would like to be, yes, I saw you waving, Miss Allen as well. Is there anyone else from the defense who'd like to join? Are you alone today, Mr.
I'm
Howard?
flying solo today, Judge.
Okay, it's one of those days. So just Mr. Howard, Miss Allen, Miss Gardner, and myself. And Mr. Hollings is welcome to join if that would be helpful to the state.
I can go sit, but I'm assuming the 2 of them can handle it.
All right, we're back on the record with the case of Mr. O'Neill. Ms. Gardner, if you give us the state's position. You're muted, Ms. Gardner.
I don't think that was me, but thank you, Your Honor. The facts in this case are back on September 18th, 2021. Officer Codner responded to a report about a suspicious person wandering around the area of Lake Haven Drive and Davidson Avenue. During his investigation, he discovered that Mr. Alberto Bruni saw the defendant on his security cameras the day before. The defendant had jumped Mr. Bruni's fence, pulled the handles on the door to his home, and also taken some beverages from Mr. Bruni's outdoor refrigerator. Given that there was an FTA very recently, the state is asking, even though this is a 2021 offense date, the state is asking for a good bond in the amount of $1,500. Stay away from the incident location at 4295 Lake Haven Drive Northeast, and no contact with Mr. Alberto, that's Alberto Bruni, which is Bruni, and no drugs, alcohol, or weapons.
All right, thank you. Mr. Howard?
Yes, Judge. Mr. O'Neill is 31 years old. He's lived in Georgia for most of his life. He tells me that he did attend some college at Brown Mackie College, where he studied to be a pharmacy tech. And speaking with him, there's some things that we're going to explore as it relates to some medical issues that he expressed to me. And as the state noted, this is an allegation from September of 2021. We did hear the recent history as it relates to FTAs. We'd ask the court to set a reasonable bond in this case.
All right, thank you. At this time, defendant will receive a $2,000 good bond, $1,000 on each count. He is to stay away from the address on Lake Haven Drive and have no contact with Mr. Bruni. Additional conditions will exist as discussed in the breakout room. Additionally, he's to have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Judge.
All right. Best of luck to you at this time, sir. I believe that concludes our entire calendar. Courtroom 2 can be excused. Have a great rest of your weekend. Take care.
Thank you. You do the same.
Okay, bye-bye. Ms. Grace, will you please review the calendar for me?
Yes, ma'am. Position number 1 is $1,000 SOB through the jail. Position number 2 is a $2,500 good bond. Position number 3 I don't write it on my calendar. Is a $1,000 good bond. Position number 4 is a $2,500 good bond. Position number 5 is a $2,000 good bond. Position number 6 is a $1,500 split bond. Position number 7 is a $3,000 SOB through the jail. Position number 8 is a $3,000 split bond. Position number 9 is a $5,000 pretrial per judge. Any questions or comment?
Nope.
The add-on separate.
We'll add on 1.
$5,000 good bond for the add-on. Thank you.
All right, I believe we've concluded the entire calendar and will now be in recess until the FCA calendar on Monday. Thank you all for your patience today. We had a little bit of a mix up at the beginning, but we still managed to finish up in a good time.
Yep.
So everyone, take
Your
care.
Honor.
Enjoy your rest of your weekend.
You
Bye-bye.
too, Your Honor.
Thank you, Your Honor. Have
All
a
right.
great day.
All right, bye-bye.